Good morning. I'm Professor Jessica Roberts, and I am delighted to welcome you to the 25th Annual FRANKEL Lecture. We are so happy to be with you this morning, even if only by Zoom. The FRANKEL Lecture, generously funded by the FRANKEL Family Foundation, began in 1995. The purpose of this lecture series is to convene leading legal scholars from around the country to discuss a socially relevant topic. Following the lecture, the speakers publish papers based on their remarks in a special issue of the Houston Law Review. We are proud to be following that tradition today, bringing together a group of highly distinguished scholars for what we know will be an illuminating conversation. Yet, in the course of the FRANKEL Lecture's illustrious history, no lecture has addressed the issue of racial violence in policing. And no FRANKEL keynote in the past decade has discussed racial justice or racism. We, the organizers, believe that these topics are long overdue. And we can think of no better place than here in Houston, one of the most diverse cities in our fractured nation and the hometown of George Floyd himself, and no better time than now, on the eve of one of the most contentious presidential elections in American history, to have this incredibly timely and important conversation. Thank you for joining us. A few brief logistical points before we get started. When I conclude, Dean Baines will provide introductions for our fantastic group of speakers this morning. Dean Unwuachi-Willig will give her keynote lecture, followed by commentary from Dean Lawson and Professor Gruber. We will then take a 10-minute break, during which I will make the CLE information available. We will reconvene around 12:30 for the Q&A. Participants who wish to ask questions should type their questions in the Q&A and not in the chat. Please address your questions to everyone. If you wish to direct a question to a particular speaker, please indicate that in the text of your question. And don't worry, I will repeat all of the Zoom instructions right before the break. Thank you again for attending, and I will now turn it over to Dean Leonard Baines.
Good morning, everyone. It's a pleasure to be here. Thank you for attending the 25th FRANKEL Lecture. We're very proud to have this lecture and have such amazing speakers. Let me tell you, for those who are not UH Law alum, a little bit about the Law Center. So it's a top-tier law school that has national programs in health law, intellectual property, environmental law, energy law, tax law, and the part-time program. And what we're most proud of also is that for 5 years in a row, the Law Center has been awarded the HEAT Award, that's the Higher Education Excellence and Diversity Award, for its commitment to diversity by Insight into Diversity magazine. As Professor Roberts indicated, this is the 25th anniversary of the FRANKEL Lecture. And the Law Review members and students are just absolutely amazing. They're smart and professional, and they have a commitment to diversity in their membership, as well as the authors that they published. I'm most proud that in their last issue, approximately 35% of the published authors were members of people who are either Black, Indigenous, or people of color, and almost half women. The Law Review and the organizers, Professor Roberts and others, were very prescient in that they chose this very timely topic and speakers before the tragic incidents this past summer with George Floyd, Breonna Taylor, and so many other African-American men and women who've lost their lives by those acting under color of law. The lecture is called Lynching as a Status Quo. It's a socio-legal discussion of the pattern of police and quasi-police killings of African-Americans. It's an honor for me to introduce this all-star panel of 3 outstanding scholars. And as Professor Roberts indicated, the FRANKEL Lecture has not really had a focus on this. And I don't think we've ever had 3 women of color as our featured speaker, keynote speaker, and commentator. So this is a very unique and auspicious occasion. So I'll introduce our speakers. I had to work very hard to try to keep the accolades that all of them have down. As Professor Roberts indicated, the keynote speaker will be Dean Onwuachi-Willig from BU Law School, and there'll be comments by Dean Tamara Lawson from St. Thomas and Professor Aya Gruber from University of Colorado. So Angela Onwuachi-Willig is a renowned legal scholar who joined BU Law School as Dean in August 2018. Onwuachi-Willig is the author of a book called According to Our Hearts, The Rhinelander versus Rhinelander and the Law of Multiracial Family, that was published in Yale University Press in 2013. She's published in many top-tier law schools and law journals, such as the Yale Law Journal, the Virginia Law Review, Northwestern Law Review, California Law Review, Michigan Law Review, Georgetown Law Journal, Texas Law Review, UCLA Law Review, and the Vanderbilt Law Review. She's a recipient of many awards, including the AALS Clyde Ferguson Award, the AALS Derek Bell Award, the Law and Society's John Hope Franklin Prize, and in 2018 academic year, she served as the William H. Newcomb Fellows Research Chair in Diversity and Law at the American Bar Association. She's also an elected member of the American Law Institute. She graduated Phi Beta Kappa from Grinnell College, received her JD from University of Michigan, where she was Clarence Darrow Scholar. She was on the Michigan Law Review, where she was note editor. She was associate editor for the founding issue of the Michigan Journal of Race and Law. And after law school, she clerked for U.S. District Court Judge Solomon Oliver of the Northern District of Ohio and the U.S. Sixth Circuit Judge Karen Nelson Moore. And she also, as I said, I had to cut things out. She has such great academic pedigree. She also has a PhD in sociology and African American studies from Yale University. So let's welcome Dean Angela Onwuachi-Willig. The commentators, let me introduce them. They also are amazing. So first commentator is going to be Tara Lawson. She's a dean and professor of law at St. Thomas University School of Law in Miami. She previously served as that law school's associate dean for academic affairs and associate dean for faculty development. Dean Lawson is chair of the Law Professors Division of the NBA, the National Bar Association, and chair-elect of the Women in Legal Education section of the WLS. At St. Thomas, she's been awarded the Professor of the Year award several times. Prior to joining law faculty, Dean Lawson served as Deputy District Attorney at the Clark County District Attorney's Office in Las Vegas, Nevada. As a criminal prosecutor, she worked on Special Victims Unit for domestic violence and argued multiple cases before the Nevada Supreme Court, including death penalty cases. Dean Lawson's premier article, Can Fingerprints Lie?, has appeared in numerous treatises, law review articles, and appellate court briefs. She's a co-author of 2 casebooks, Criminal Procedure, Cases and Materials, and Evidence, Cases, Materials, and Problems. And her scholarship has been included in a book chapter, Contemporary Controversies, Forensic Technology, and her article about Trayvon Martin has made her the go-to media expert on these issues, and she's the reporter for the American Bar Association Task Force on Stand Your Ground laws. Let's welcome Dean Tamara Lawson. And our last speaker is Aya Gruber, who's a law professor at University of Colorado and an expert on criminal law and violence against women. She has previously taught at the University of Iowa Law School and Harvard Law School. She graduated from UC Berkeley and Harvard Law School, after which she served as a public defender in Washington, D.C. and Miami, Florida. Her widely taught and frequently cited scholarly articles combine insights from practice, and her scholarship has been referenced by the New York Times, the New Yorker, Slate, and other media outlets. Professor Gruber's debut monograph, Feminist War on Crime, The Unexpected Role of Women's Liberation in Mass Incarceration, is the first book to detail the history of American feminism's contribution to mass incarceration. Professor Gruber is a member of the American Law Institute and a frequent public commentator on criminal law issues with appearances on ABC, NPR, PBS, and many other outlets. So as you can see, it's an all-star panel. We have certainly the academic perspective, but we also have the practical perspective from someone who was a former prosecutor, Dean Lawson, and someone who was a former public defender, Professor Gruber. So I'd now like to turn the mic over to Dean, BU Dean and Professor of Law, Angela Unwuachi-Willig. Thank you so much.
Thank you so much. Thank you so much, Dean, Dean Baines. I'm delighted to be here. Thank you very much for that kind introduction, and thank you for your support of this program. Thank you very much for all of your mentorship and advice and great counsel throughout my entire career. I'm incredibly grateful for it, and you are very lucky to have Dean Baines as the leader of the University of Houston Law Center. He's a fantastic leader and a wonderful mentor. He's been a wonderful mentor to me. So I want to start by saying a couple of things. I want to start by saying, first, we've agreed, as I go a little bit long, we've agreed that I would go a little bit long and that the commentators would go a little bit shorter. So I'm not purposely flouting the rules, but we are without intention. And I also want to thank a few more people. I want to thank everyone who has showed such great hospitality to me throughout this entire preparation for this event. Everyone who was at the Zoom dinner last night for great conversation, for their incredibly warm welcome, for their good company. I want to thank Dean Sandra Tennessee, Dean Vetter, as well. I want to thank the former EIC of the Houston Law Review, Drew Padley, for being on the committee that helped to select me to give this lecture. I want to thank the Houston Law Review in general for this fantastic honor to give the FRANKEL lecture. I want to thank Reagan Lutter and Priya Kasnavia for their fantastic work, and in particular, Priya Kasnavia for all of her very, very hard work in preparing what is really a fantastic event. She's really incredible. All the students are really incredible. I want to thank Professor Roberts, Jessica Roberts, who I've been a big fan of her work for a very long time, for agreeing to moderate this discussion. And of course, I want to thank my wonderful colleagues, Dean Tamara Lawson and Professor Aya Gruber, for agreeing to be a part of this conversation. And I want to thank you for showing up for this lecture. I'm really delighted to have this opportunity to share my work with you. So I want to start by saying it's not only a great honor to be giving a lecture for such a distinguished law review and to work with such a talented group of young people. It's a great honor to be giving this lecture on my work, even though virtually in my hometown, which is Houston, Texas. I was born and raised in Houston. I graduated from Sharpstown High School. I grew up on the south side of the city in different apartment complexes throughout my childhood. My connection to Sharpstown is brings me to another reason why I feel grateful to have this opportunity to share my work with the community in Houston at this moment. As a graduate of Sharpstown, I feel a special kinship with graduates of Yates High School, with whom we would compete in sports every year and usually lose. And as you all know, the whole world was moved by the brutal and brazen manner in which we all saw former officer Derek Chauvin kill George Floyd, a former Yates football star, a father, a son, a brother, a boyfriend, a partner, someone who was loved deeply by so many in his family, by his friends. And he was brutally murdered by former officer Derek Chauvin, who kneeled on his neck with a smug smirk on his face for 8 minutes and 46 seconds, as though Mr. Floyd was not a person at all. And so it's my great honor that the Houston Law Review has given me this opportunity to help remind us all, including myself, why this ultimate sacrifice that Mr. Floyd and his family involuntarily made must not be made in vain. So the lecture that I'm giving today actually extends beyond the paper that I'll ultimately publish in the Houston Law Review. In fact, my lecture will touch upon various aspects of a larger book project that I'm working on, ending with part of the book that will be the part of the book that will be the focus of my essay in the law review, an essay entitled "The Trauma of Awakening to Racism: How the Killing of George Floyd Resulted in a Cultural Trauma for Whites." Now, my book examines the impact of police and quasi-police killings of unarmed African Americans, and more so, the impact of repeated acquittals and non-indictments that have frequently followed these killings on African Americans as a group. And that book project is tentatively titled "Traumatized: From Lynching as Status Quo to the New Status Quo." And that book looks at how, in particular, the legal outcomes in these cases, right, can deepen our understanding about what sociologists have defined as cultural trauma. Let me share my slides with you. So according to Professor Jeffrey Alexander of Yale University, cultural trauma occurs when members of a collective feel they've been subjected to a horrendous event that leaves indelible marks upon their group consciousness, marking their memories forever and changing their future identity in fundamental and irrevocable ways. Now, I first came to work on cultural trauma unintentionally and even unknowingly prior to really beginning to work on my more recent research, much of which really revolves around the killings of Emmett Till and Trayvon Martin and the trials of their killers. I really wrote scholarship in the areas of family law and employment discrimination, particularly and on affirmative action. And even though I, as a citizen, was certainly interested in the police and quasi-police killings that African Americans as a group have largely perceived to be unjust, I had not been moved to write about these killings and their legal outcomes. And then on February 26, 2012, George Zimmerman, the then 28-year-old man of white American and Peruvian descent, who served as a neighborhood watch captain for his gated community in Sanford, Florida, shot and killed 17-year-old Trayvon Martin, an African-American boy who was a guest of a resident in the same gated community, and he was walking home from a run to a local convenience store to buy Skittles and to buy an Arizona watermelon soda. An unarmed Trayvon Martin had nothing on his person but his cell phone, an Arizona watermelon soda, a bag of Skittles, $40.15 in cash, a cigarette lighter, and some headphones. Now, I wish I could say that 2012 was a unique year with respect to the killing of an unarmed African-American boy like Trayvon, followed by an acquittal of his killer, but it was not. In fact, long before 2012, J.W. Milam and Roy Bryant, two white men in Mississippi, escaped judicial punishment for their brutal beating and murder of 14-year-old Emmett Till in 1955. In fact, since the founding of this country, violent killings of unarmed African Americans, including lynchings, have occurred over and over again, frequently without any punishment for their killers. And yet it was Trayvon Martin's slaying in 2012 that drew my personal attention like no other. And I can't exactly explain why 2012, as opposed to any other year, compelled me to think about writing about these killings. But I suspect that it had something to do with the fact that my oldest son turned 14 in 2012. After all, 14 was the age of Emmett Till when J.W. Milam and Roy Bryant killed him during the summer of 1955. And that fact, coupled with viewing pictures of a young Trayvon Martin in his football uniform, left me, to some extent, traumatized in the psychological, meaning individual, as opposed to sociological, meaning group sense. Seeing Trayvon Martin's childhood photographs day in and day out forced me to look at my own son who is as non-threatening as can be, and consider how others may view him as threatening for no reason other than his skin color, gender, and age. And to these people, it would not matter how smart my son is, or how tender he is with his little brother, or how much he loves watching the British television program Doctor Who, or even how his favorite thing in the world is simply to listen to Korean pop music and watch Korean pop videos. All that would matter to these people was that he was brown, matched by a height that signals that he is no longer just a kid. And it was not lost on me that this risk was even more prevalent for the children of African Americans like me. This particular risk that Trayvon Martin faced, those in the middle and upper middle class, those Blacks who were most likely to find themselves integrating neighborhoods where white residents may question their place and belonging, or view them or their children as strangers to them, and in some cases, even when known to them, as suspects. And I would be remiss if I did not note that it was this privilege, this sense for so many of us, with the type of social capital that most African Americans do not have, that helped to make Trayvon's story a national story, just as Emmett Till's northern roots and middle class status, at least within the African American community at that time, had done in 1955. Like President Obama, who asserted during a press conference, if I had a son, quote, if I had a son, he would look like Trayvon. And much like Northern Blacks were forced to do when Illinois-born Emmett Till was murdered in 1955, in 2012, I, like parents of African-American children before me and all around me, grappled with the notion that it could be my son next. So soon after George Zimmerman was acquitted of the charges against him, I discovered this burgeoning body of scholarship around cultural trauma. And as scholars like Jeffrey Alexander and Ron Ironman have explained, it's not all of these tragic occurrences, these tragedies are result in cultural traumas. It's not the event in itself that creates the trauma. What ultimately matters in determining cultural traumas is whether a disorienting event is effectively communicated as a trauma. In other words, an event or situation or tragedy must not only be disorienting, but must get defined and narrated as a trauma. And as part of my larger book project, I stepped back to decipher the very pattern that brings us to this form of cultural trauma for African Americans. And I do so by asking and answering, what is the cycle, if any, that creates and recreates the group-based trauma that African Americans experience, not only after these killings, but more so after the legal responses that have consistently communicated to society that Black lives do not matter. As the title suggests, I refer to this pattern or routine as the new status quo. And I begin really here with Tamir Rice because the idea that there was this pattern hit me as I was following the Tamir Rice case. I remember when it came out and I was thinking this is a case of a 12-year-old person, and I was so used to seeing people being demonized after they were killed, and I thought, there's no way anyone's going to try to demonize a 12-year-old boy. And then it began, not necessarily with the demonization of Tamir Rice, but the demonization of his family, his parents. Right? And then it began. These things follow in patterns. And so I began to study and to look at newspaper articles to see what were the patterns that I could pull out. So on December 28, 2015, a grand jury decided not to indict Officer Timothy Lohman for the fatal shooting of Tamir Rice, a 12-year-old African-American boy who was playing with a toy gun outside of a recreation center in Cleveland, Ohio. So although many individuals consider the grand jury's decision to be a grave injustice, few were shocked by the outcome. In fact, one of the attorneys for the family responded to the non-indictment by proclaiming, quote, Tamir's family is saddened and disappointed by this outcome, but not surprised. Others, like Reverend Jawanza Colvin, an African-American pastor at a Cleveland church who had pushed for Lohman's arrest, expressed similar sentiments. Colvin declared, quote, "The fact that we are not surprised by the grand jury's decision is in and of itself an indictment of the culture of the criminal justice system." So these responses by the Rice family and their supporters should not be read solely as a pessimistic outlook on the justice system in the United States. Instead, they should be understood as measured responses to a sociological pattern of events and decisions that have developed in cases involving police and quasi-police killings of unarmed African Americans. And by quasi-police, I'm talking about people like neighborhood watchmen or people who see themselves functioning in an enforcement role, like the men who killed and followed jogger Ahmaud Arbery. And we're talking about a pattern that begins with a tragic killing or a horrific beating of a non-threatening, think Philando Castile, or unarmed African American, that is frequently followed by an acquittal or a non-indictment of the officer or quasi-officer, and that ends in a cultural trauma and a sense of hopelessness and disappointment in the legal system. So just like sociologist Oliver Cox delineated the sociological pattern of early 20th century lynchings and their aftermath in a piece, a seminal piece called Lynching and the Status Quo in 1945, I argue that today's police and quasi-police killings of unarmed African Americans or non-threatening African Americans, like specifically Trayvon Martin, Michael Brown, and Tamir Rice are the examples I use, occur in a recognizable sociological pattern or cycle. And in talking about this pattern, I want to talk about I'll take these following steps. First, I will describe some parts of Cox's article, adding insights where appropriate from existing literature about lynching in the United States. Thereafter, I want to identify, define, and explain the 9 distinct stages of what I'm calling the new status quo. And then I'll give a brief analysis of the thousands of what I found in the thousands of newspaper articles that addressed not just the killings of Trayvon Martin, Michael Brown, and Tamir Rice, but also the resulting legal processes in those cases. And then when I come to one of those stages in particular, the cultural trauma stage, I want to discuss some of my research with the people that I interviewed about the legal outcomes in these cases. And then finally, I want to end by considering what's going to be really the part of my article that I'll publish in the Houston Law Review, whether whites' widespread viewing of former officer Derek Chauvin's slaying of George Floyd for nearly 9 minutes on film has resulted in a cultural or group-based trauma for whites within the United States. So first, let's talk Oliver Cox and lynching as status quo. So in 1945, Oliver Cox offers an incisive, clear analysis of the phenomenon of lynching in his article. And Oliver Cox was responding to people who were who were making claims that lynching was a spontaneous act of mob violence in the interest of social order against a criminal who had committed a heinous and socially revolting act. Oliver Cox was responding and disputing those claims, and he outlined in doing so each step of what a pattern that he said described both the circumstances that could lead to a lynching, the lynching itself, and the aftermath of a lynching. He defined lynchings as, quote, an act of homicidal aggression committed by one people against another for the purpose of suppressing either some tendency in the latter to rise from an accommodated position of subordination or for subjugating them further to some lower social status. And he noted that lynchings weren't simply about an attack against individual African Americans, but about an attack against African Americans as a group. It was about social control. It was about subordination. And he said the circumstances under which lynchings arise, right, are where there's rampant and consistent discrimination against a targeted group. And lynchings occurred mostly in areas where the laws discriminate against that group. And he took notice of the fact, right, that an administrative judicial machinery may even facilitate these lynchings. He also explained that there are particular times where they might arise, they may be in more frequency. And those are in times and in contexts where whites believe that their privileged racial status was at risk of being lost or diluted, or where whites had begun to develop a summary attitude of racial antagonism and tension. The most frequent excuse, of course, was that the idea was that an African American had committed a crime against a white person, and in most instances, the alleged crime was rape of a white woman by an African American man. As so many scholars have shown and proven, in nearly all instances, these were false. The real purpose behind the brutal lynchings was not the actual alleged crime, but instead a white desire to maintain and reinforce the subordination and oppression of African Americans as a group. The charges were almost always trumped up. In fact, the real charge was usually that the lynching victim or victims were people who were subverting or who were challenging the social order or racial hierarchy. And by targeting what they viewed as uppity Blacks, white segregationists intended to send a message to all African Americans that they should stay in their place. Because if prominent and powerful, right, or people who were willing to challenge the social order could not escape the horrors of lynching, then who could? Not surprisingly, lynching was greatly feared by many African Americans. And to ensure that African Americans remained frightened and reluctant to challenge and protest racial hierarchies, the leaders of lynching mobs frequently left the bodies of their lifeless victims out on full display in public as a symbol of white power and dominance. And the aftermath of every lynching involved some type of legal process. Cox explained, quote, within 2 or 3 days, the mob achieves its emotional catharsis. There is a movement for judicial investigation. And during that time, some of the best white people speak out against the lynching, end quote. And some of the ministers of, quote, of great courage may even label the violent acts as barbarous and unchristian. And ultimately, though, justice was very rarely served on behalf of the lynching victim. The participants in the public lynching mob were almost never punished, even though there were many people there and you could see everyone there. It didn't matter that state statutes frequently identified such violence as a crime. And in time, even though there would be grand jury investigations and hearings, they would often return with findings that the deceased came to his death, quote, by hanging and gunshot wounds at the hands of parties unknown. So basically, during the late 19th and early to mid 20th century, lynchings of African Americans in the South were simply not considered to be criminal. And in fact, lynch mob participants rarely even feared actual punishment. They were committed in open public, and they acted in ways that revealed their complete lack of concern about the possibility of being held legally and socially accountable for their actions. There was a common understanding that they could engage in these acts with impunity. Cox surmised that the law was simply not available to African Americans. And as further evidence of the absence of rights for African Americans, he listed some of the, quote, what he calls, quote, apparent trivialities that African Americans had been accused of and purportedly lynched for, including the acts of, quote, using offensive language, bringing suit against white men, trying to act like white men, frightening women and children, being a witness, gambling, making boastful remarks, and attempting to vote. Cox explained that even in those cases where the public agreed that the lynchers had gone too far, the public was reluctant to place too much blame on the lynchers, quote, because their provocation was great and their ultimate motives were laudable. So now we're at the new status quo. Today, the 20th century mob lynchings that Cox described in his article are far less likely to occur, of course, regardless of region. People are, in fact, if people were to proclaim outwardly racist views, they would be looked down upon in our society. And still, African Americans remain disadvantaged and subordinated in society in essentially every arena. And many whites continue to deny the existence of the systemic nature of racism. This form of thinking, what Professor Sumi Cho calls post-racialism, extends to views about police brutality, or at least they certainly did before the murder of George Floyd. However, in the eyes of many, these killings of unarmed African Americans have become a new legalized form of lynchings. And much like those who argue that lynchings of the early 20th century were spontaneous acts motivated by illicit crime, individuals today who dispute the idea that racial bias underlies many police shootings, strangulations, beatings of African Americans argue that these killings are not systemically connected. These post-racialists attribute the killings of unarmed African Americans by police and quasi-police to the actions of the deceased and maintain that race has played and is playing no role in these tragedies. They maintain that the victims of these tragedies would still be alive had they acted differently, had they not been selling Lucy cigarettes, as Eric Garner was alleged to be doing on the day he was choked to death. Or had they simply explained who they were in their own neighborhoods or the neighborhoods where they were a guest to a complete stranger who had been creepily watching them from his car, chased them, and had not bothered to identify himself as someone who belonged in the neighborhood himself, like many have said about Trayvon Martin? Or had they not removed the orange tab on their toy gun, like many have said about 12-year-old Tamir Rice, who did not actually remove the orange tab from the gun, but received the gun in that condition from a classmate? Or had they not been walking in the middle of the street during the day, like many have said about Michael Brown, who was walking in the middle of the street where there were no sidewalks? Sadly, this list resembles a list of apparent trivialities that Cox highlighted as the proclaimed reasons for the lynchings of African Americans in Lynching and Status Quo. As Cox and other scholars have pointed out, the real reason behind these violent tragedies are not the stated ones. The real reason is social control, the protection of racialized geographic boundaries, and the preservation of existing racial hierarchy in our society. In some cases, the same visual signals that were delivered to communities to communicate such control by those in power and the powerlessness of those being controlled during the time of rampant lynchings are used today, were used in more recent times, contemporary times. For instance, much like lynched Black bodies were frequently left on display as a sign of white dominance and a warning to Blacks, the lifeless body of 18-year-old Michael Brown was left to fester in the summer sun for 4 unusually long hours on August 9th, 2014 in Ferguson, Missouri. In fact, Ferguson Committeewoman Patricia Bynes asserted that the extreme delay in removing Michael Brown's body from the street that day, quote, sent the message from law enforcement that we can do this to you any day, anytime, in broad daylight, and there's nothing you can do about it, end quote. Additionally, much like scholars and commentators who describe early 20th century lynchings as spontaneous acts meant to punish heinous crimes from African Americans, today post-racialists argue that police or quasi-police shootings of African Americans are instinctive acts of protection motivated by rational police fear. And even in cases where the public agrees, as Cox said, that officers or quasi-police officers have gone too far, as in the case of George Zimmerman, when people said he should not have ever gotten out of his car, or Officer Daniel Pantaleo, whose chokehold killed Eric Garner, the public remains reluctant to hold them legally accountable because, as Cox said, quote, their provocation is great and their ultimate motives are laudable. Also, just like with the lynchings of the early 20th century, almost always ended with grand jury findings that the deceased came to his death by hanging and gunshot wounds at the hands of parties unknown. Shootings and other killings of unarmed African Americans by police officers today almost always result in no punishment for those who did the killing on the grounds that the officer or quasi-officer reasonably feared for his life. It did not matter that George Zimmerman was not even a police officer or that he disobeyed orders to remain in his car. And in Tamir Rice's case, it did not matter that it was not even possible for the officer to even give one warning to Tamir, much less the 3 he lied about giving to the 12-year-old in his police report when he shot the young boy in with fewer than 2 seconds of his arrival on the scene. Even the killing of George Floyd a tragedy for which 65% of the respondents in a nationally representative poll agreed that Officer Derek Chauvin murdered Floyd, and another 25% of respondents said that Floyd's death was partly a product of excessive force, but not murder. A conviction of Chauvin, who kneeled on George Floyd's neck for nearly 9 minutes, including 2 minutes after Mr. Floyd stopped moving, is not a foregone conclusion. In fact, Keith Ellison, the Attorney General of Minnesota himself, warned, quote, "Trying this case will not be an easy thing. Winning a conviction will still be hard." Moreover, just as spectators and participants of lynchings acted in ways that revealed they had no concern for being punished by the law, officers who have killed unarmed African Americans have engaged in actions that one would not readily see from those who truly feared punishment. For instance, many officers have testified before a grand jury, an action most criminal defense attorneys have explained they would not allow their clients to do unless they were certain there would not be an indictment. And then consider how former Officer Derek Chauvin so openly and brazenly continued to kneel on George Floyd's neck as he cried out for help, even as Chauvin knew he was being taped. And in so doing, effectively communicated quite effectively that he had been engaged in such behavior before, and more so that he did not fear being punished for it at all. Stephen Jackson, a childhood friend of Mr. Floyd and a former NBA player, said it best when he noted the following about the former officer. Quote, "You can't tell me when that man, Chauvin, has his knee on my brother's neck, taking his life away with his hand in his pocket. That smirk on his face didn't say, 'I'm protected.' He knew he was going to get away with it. You can't tell me that wasn't the look on his face," end quote. So whereas lynchings during the early 20th century were openly supported and condoned by an explicitly racist legal system, including explicitly racist law enforcement officers, the killings of unarmed African Americans that occur in today's post-civil rights era are instead channeled through a formal legal system that claims to value and protect all life equally regardless of race, but that too frequently renders outcomes that fail to acknowledge and recognize the racial bias, both conscious and non-conscious, that have led to the disproportionate killings of unarmed and non-threatening African Americans, and thus result in less protection for African Americans under the law. And so, like Cox explained in 1945, there's a pattern of events that occur after a police or before and after a police or quasi-police killing. And I say this has 9 stages to it, starting with the killing itself, and I'm going to just briefly go over a few examples from each of the stages, right? And these are the 9 stages. The killing itself is the first stage. The second is the use of media, right? So in many cases, ideally you wouldn't have to use, right, protested media to get a conviction, because it would happen, because the life would be valued, right? But in these cases, there has to be the use of media and protests to bring attention to the killing of the unarmed Black person in order to get some kind of action. The denial of the role of racism in the incident by a significant number of white Americans, promises for an investigation or swift action by those in power in response to the uproar from the Black community and its allies, the demonization and in some cases the super-humanization of the beaten or killed Black person, the acquittal or non-indictment of the officer or quasi-police officer, the cultural trauma for Blacks, then continued advocacy for reform or change by people, Blacks and allies, and then the letdown and disappointment following the recurrence of a similar incident in the country. So of course, the first stage is the tragic killing or beating of African Americans by a police or quasi-police officer. Of course, the event from my childhood I remember the most is, of course, the beating of Rodney King. The use of media to bring attention to the killing of the non-threatening Black person, and this is really a playbook, a step that many people have followed, that Mamie Till Mobley, who was a mother of Emmett Till, was famous for using. She's the first person really to employ this. She gets the black newspapers, black magazines, who published pictures of her son's face. And she says, I want the world to see what racism looks like. And that really changes things, because people are forced to confront the ugliness of racism in the same way that I will argue later, that the taping, the video of George Floyd's murder also forces people to confront the ugliness of the murder. And you see Benjamin Crump, who's, along with Lee Merritt, one of the primary civil rights attorneys representing so many of these families, is a really expert at being able to use the media to bring attention to these killings and ultimately gain some ground to at least get some action from those who can either bring the cases before grand juries, or in the case of Trayvon Martin, actually get Angela Corey herself to use her own authority as a state attorney general to file charges. The third stage is the denial, the role of racism in the incident. It could be anything from it wasn't racial profiling, is what we heard in Trayvon Martin. Trayvon Martin didn't listen. And it was really about the burglaries that were happening in the area. He shouldn't have been wearing a hoodie, all those things, right? That there was all these things. The same thing with Michael Brown. He was a thug who stole cigarillos. It didn't matter that Darren Wilson didn't know about that. It didn't hear. That wasn't why he stopped him. It wasn't any of those things. Tamir Rice should have listened to the officer, even though it's being quite clear the officer could have never even warned him once, much less 3 times, as he said. He was shot because of the orange tag, right? And never once was anyone ever asked a question, right? If there was a white child in those, or white person in any of those situations, would that have been the same outcome, right? The promise of action in response to it. Sometimes you get an indictment, sometimes you don't. I added the most recent, the state attorney general in Kentucky, who's the most recent person who's come under fire for the lack of indictments and the lack of indictments and the actual charge in one indictment of the officers in the Breonna Taylor case. But the promise of investigation action doesn't usually come on its own, because there's a value seen in the life, right? And there's a wrong seen in the action of the officer in and of itself, even in the case of George Floyd, right, which most Americans agree on, right? It only usually comes in response to anger and uproar and protest, right? I'm running out of time, but I want to just get to the things that I think are really super compelling. You see the demonization and superhumanization of people. Here's a picture of Michael Brown, 6'4". Michael Brown may not have had a gun, but he wasn't exactly unarmed. The guns in his arms, his strength, match those of bullets, right? And I want to read for you in particular this testimony from Darren Wilson. This is Darren Wilson's testimony, parts of his testimony during the grand jury proceedings in St. Louis County. So Darren Wilson says, speaking of Michael Brown, he was just staring at me, almost like to intimidate me or to overpower me. And Darren Wilson is himself as tall as Michael Brown. When I grabbed him, 6'3" or something. When I grabbed him, the only way I can describe it is I felt like a 5-year-old holding on to Hulk Hogan. Hulk Hogan, that's just how big he felt, how small I felt, just from grasping his arm. After seeing blood on my hand from broken glass, I looked at him. He kind of stepped back like this. And then after he did that, he looked up at me and had the most intense, aggressive face. The only way I can describe it, it looks like a demon. That's how angry he looked. He comes back towards me again with his hands up. And then Wilson then testifies that his gun went off twice inside his vehicle, that Brown ran away, that he followed Brown, and that Brown, without explanation, eventually turned around. He says, he turns, and when he looked at me, he made like a grunting, like aggravated sound, and he turns, and he's coming back toward me. His first step is coming towards me. He kind of does like a stutter step to start running. At this point, it looked like he was almost bulking up to run through the shots. Like it was making him mad that I'm shooting at him. And the face he had was looking straight through me. Like I wasn't even there. I wasn't even anything in his way. So here's a superhumanization of Michael Brown. We see this in the Trayvon Martin case as well. I've written about that. And of course, we first see this in Rodney King, right? They actually talk about Rodney King's superhuman strength as one of the bases, one of the reasons why they're beating him over and over again, right? Other types of things, right? This is not even Trayvon Martin right here, this below picture, right? So a lot of times the fake photos of other meant to be pictures of other menacing looking, they're meant to be pictures of menacing looking young men, and all kinds of things about repeatedly calling people thugs, and there was even with Trayvon Martin, this idea that somehow he was getting Skittles in Arizona, watermelon soda, so that he could mix it with some kind of cough syrup to create a drug called lean, which could cause psychosis and aggression over the longer term, right? And he was getting Skittles for Chad, who was the young son, who was a 14-year-old son of his father's girlfriend, where he was staying at her house as a guest. This is not Michael Brown, but this is a picture that circulated, again, part of the demonization of Michael, that's saying this is Michael Brown. Joda Kane was the name of the person. Then you have the acquittal, the non-indictment of the person. In all of these cases, though, I would say that all these people then lost their elections following that. Angela Corey, of course, gets ousted in Florida. Scott McCulloch gets ousted in Bob McCulloch gets ousted in St. Louis County, and Scott McGinty gets ousted. Tim McGinty gets ousted in Cuyahoga County. All of them get ousted, but all these acquittals, non-indictments in all of these cases. I believe there have only been 2 cases, right, of African Americans. There have been cases where the officer has been African American and the victim has been white. But there have been cases where the victim has been African American. There are 2 cases. They're both in Dallas. One was with the African American high school kid who was a passenger in a car. The kids were leaving a party. The officer shoots as they're driving away. They couldn't find anything. There was nothing to demonize the kid all about. And the case also, Gene Botham, who was shot in his own apartment, right? The officer enters his apartment and shoots him dead, who also was hard to demonize. The cultural trauma. So I'll tell you a little bit about cultural trauma. The cultural trauma, there are 2 types of cultural trauma that I found in my interviews of people that occur. One is the trauma of what I would say, what I'm calling the trauma of the routine. And it's a trauma, it's an extension of cultural trauma theory, because cultural trauma theory says that cultural trauma comes out of things that are shocks. You don't expect them to happen. They're complete shocks. And I'm challenged that with the trauma of the routine, saying actually, these things are not shocks to the routine, but they're still traumatic for African Americans as a group, because there's an aspect, in particular, I was looking at the pre-civil rights era when I was making this argument, is that there was an expectation that there would be these repeated injustices for African Americans, and yet they would have these devastating impacts, right? So the acquittal of Emmett Till's killers, even though everyone, including Emmett Till's mom, says expected that there would be an acquittal, right, is that it had a deep, huge impact because of the message, what it communicates to African Americans as a group about the lack of protection under the law, the value of Black life in society, and so on. So trauma of the routine, and then the trauma of injustice is what I say. It's really a post-civil rights sort of emergence, and it's really more of a different kind of shattering. It's a shattering of a belief. If for some people, and you see a split now in contemporary society, a belief that the justice system will work equally or work more favorably for African Americans, or much better for African Americans than it has in the past. And so you think that there will be justice, but there isn't justice that occurs. And I'll just give you 2 examples from 2 people in my 2 subjects who I interviewed. This is an empathy example. I'm going to do this. No, I guess I'll do this because I think it's important for people to do this, but I'll do this before I give you my examples. But really important empathy example to think about that an author wrote. If you're a white person, try this simple empathy experiment. Imagine every one of those police killings you've seen in the last several years, but change images. Make the man getting shot look like you, your brother, or your son. Make the girlfriend or wife look like your wife, your sister, your daughter. Imagine these videos unpredictably show up in your Facebook stream or assault you on the evening news without warning week after week. There seems to be no end to them, and there seems to be no way to predict when it will happen. Imagine that you can't hide from them, your son or your daughter, if you have one, because you're too scared to not tell them about it. Imagine that you feel you have to expose your child to the videos because they may not be safe if they don't know what the world is really like. Now imagine driving down the street with a broken tail light and getting pulled over by a police officer. The empathy experiment could go on, and it should, because the differences don't stop there. Add in the layers upon layers of trauma that are part of the Black experience in America, but not a part of the white experience. Try to imagine all of it to really shift perspectives and understand what it is like to live the experience of these videos as a Black person in the United States. So talking about the trauma of the routine, what I did is I've been interviewing lawyers, Black lawyers and law students about their reaction to both the killings, but also really to the legal outcomes, the repeated non-indictments and acquittals in these cases. And here's asked a 39-year-old Black female lawyer on the acquittal of George Zimmerman. She expected a charge in the case, but didn't expect a conviction. And so she says and responds, I was not expecting anything in terms of a conviction. It was not shocking to me that he did not get convicted, but it was heartbreaking. So something can be both not expected and also devastating. That's what it felt like, that nothing has changed and that I needed to be afraid. I remember listening to the announcement. It was in the evening, I think several hours after the jury has been dismissed and the police were out. And my son was a couple of months old. And I remember listening to it and then walking to his bedroom while he was asleep in his crib and just crying over his crib. It said to me, this could be my child. Nothing has changed. I brought a young Black male into this world where someone can kill him in the street for just living and there will be no justice for him. And this was both not surprising, but also devastating. It marked a real cynicism in my thought about race in the United States. Before then, I don't think I was optimistic, but I wasn't as cynical after that. And I said to her, followed up, when you said nothing has changed, you mean nothing has changed from when? She says, from slavery. I mean, that's been a little, that seems a little bit extreme, but because people are not traded as property anymore. But the sense that there are some people who are second-class citizens, the sense that Black people are not fully human, the sense that white people can treat Black people like they're not fully human and get away with it, and that people would not only let them get away with it, but that it would be considered justified, that none of that has changed. And so the optics feel different, and obviously people are not getting lynched right. But a commitment to subordination of Black people is still there, and that hasn't changed. Final quote I'll share from her as an example of trauma of the routine. She's talking about the impact. What's the impact of the repeated acquittals and non-indictments in these police and quasi-police killings? It corrodes your sense of safety. It corrodes your faith in your democracy. It corrodes relationships with people who are not willing to engage the horror of these repeated incidents. And that, when you think about the things like hypertension, depression, heart disease in Black communities, and I think this is a lot of it, this ambient stress that never goes away because one, you realize it could happen to you, and two, nobody around you is talking about it until there's a gaslighting effect of it, right? Like, I know this thing is happening, but y'all sit around here in the coffee room like it's a normal Tuesday, right? And so I think people underestimate how much it corrodes, and the lack of sensitivity to that is double injury on top of the actual acquittal itself, and I think people underestimate the sense of that. An example of trauma of the injustice is as a 45-year-old Black female lawyer on the acquittal of George Zimmerman. She was confident when she first heard of the killing of Trayvon Martin. She was devastated, but she was confident that that was going to work out, that there would be some accountability. And so she says, after the acquittal, it was just horror, deep, not just sadness, but this sense of powerlessness, because I have a young son who was very young at the time. He's now approaching the age that Trayvon Martin was at the time that he got killed. I just, as a mother, I felt powerless. It was just the most heart-wrenching thing. Like I said, I can really just feel how I was very emotionally distraught when that verdict came out. I mean, I was just, oh, clearly this is not the way the law is supposed to work. I think that was a moment that I really did get a greater consciousness of the moment we now realize that we're in, which is the Black Lives Matter moment. I think that we all developed a more acute awareness of just how far we have not come, because there was this sense that we made real progress. After all, we were celebrating, we were just still giddy from the first Black president. Everybody had celebrated how far we had come. Like, I had brought myself out of one socioeconomic strata into a whole other strata for my own life. The acquittal was a very stark reminder that Black people were still very much threatened in the public domain, simply because we were Black. We were feared, particularly Black men. That gave me real great concern as a mother, as a wife, as a Black woman, and as an activist and a scholar, that we really had a lot of more work to do, that we all thought when we celebrated the election of Barack Obama. And talking again about the meaning of the acquittal for Blacks, it meant that our justice system that we are expected to put our faith in to really resolve grievances on behalf of us as citizens, our legitimate grievances, was not available for me as a Black citizen, right? It just did not work for me. It meant we also can't engage in self-help because that's going to get us in trouble. Again, it's this overwhelming powerlessness. It's what are you supposed to do? What options are you left with? You can't protect them. You can't vindicate them. You can't vindicate yourself. How are you supposed to exist in the world? It just felt so incredibly unfair, so frustrating, so overwhelmingly, like I said, it was completely disempowering. It's not just that juries acquit. It's that prosecutors fail to charge. It's that police officers cover up. That the media spins by finding a joint in a bag or finding a tape that says maybe he did something. I don't know at this point. I guess I'm grappling with that reality. I want to share. I guess I want to share her next quote, because she's talking about, and I think this is really important because she's talking about, I think, almost involuntary intergenerational trauma, right? What are the effects on parenting? She's talking about the warning she has to give to her sons. So we have to have a conversation about how you don't get to move through the world like a white boy, and that's just not how you get to live your life, because you're not going to be given the same benefit of the doubt. You're not going to be treated the same. So she's saying to her son, the consequences are going to be different for you, and they could be deadly. I can't have that on my conscience. I need you to understand how to protect yourself, and part of it is not just engaging in these protective acts when you interact with police. People talk about how Black parents deprive their children of the innocence of youth because we punish them and we're overly restrictive, and kids should have the freedom. No, you deprived us, society, of giving our children the innocence of their youth, because now we can't allow them that. I feel horrible that I can allow my child the innocence of youth. I'd much rather have my child lacking the innocence of youth than to have my child enjoy his youth and perhaps die because of it. I mean, I just can't make that trade-off. Let me quickly go through the next two stages. You see continued advocacy and reform, of course, right? Always hope, always fighting for justice. And so many people have said, you know, really a great love for the country is a belief that it can be better and fighting for better. You see Lucia McBath, whose son was killed. Jordan Davis was killed outside of a convenience store not too long after Trayvon Martin shot and killed. His killer actually went to jail. She's now a U.S. representative, and Sabrina Fulton is now running for office as well, too, as a commissioner of Miami-Dade County Commissioner. And I finally want to leave you with some, and then, of course, the letdown and the reoccurrence we see of the continued cycle. I want to leave you with some potentially more uplifting news, which and that news is that we might be in a unique moment for change, because for a meaningful number of white people, having to witness the killing of George Floyd, as he cried out for his mother, as he cried out for help, the officer who was under no duress, under no threat, kneeled on his neck for nearly 9 minutes, and his partners who had a duty to save people, that's their job, is to save people, did nothing to save Mr. Floyd, and actually simply assisted their partner. Watching that video really enabled an awakening to racism for whites that arguably resulted in a cultural trauma that has led to the protests, the most multicultural protest. And in fact, one of my colleagues, Professor Karen P. Lohr, talked about actually the majority of the protesters are are whites. And so as you see something, a shift that we haven't seen before, and you've seen a shift too also across political perspectives. So for example, consider this quote from Daryl Austin, who is a white male heterosexual business owner, self-identified Republican journalist, father, works and resides in Utah. He voted for Trump in 2016. And he still was, February 2020, wrote an op-ed about how he was openly debating about whether he was still going to vote for Trump in 2020, so he hadn't done it. He wrote, in June, wrote an op-ed about the impact of the George Floyd murder on him. And so here's what part of what he wrote. He said he'd been living too long denying the existence of systemic racism. And he wrote, quote, like many other people, I watched in horror with anger when I saw former Minneapolis police officer Derek Chauvin kneeling on the neck of George Floyd. For nearly 9 agonizing minutes as Mr. Floyd pleaded for air to breathe, and 2 additional officers used the weight of their bodies to push Mr. Floyd's body into the filthy concrete. Could not help but wonder how everyone could participate in such an act of sheer inhumanity. I didn't understand how it could have come to pass that they somehow saw George Floyd as being less. Seeing it unfold before my eyes, or maybe seeing this act unfold after seeing so many other similar acts unfold in a similar fashion over the last few years, has had a profound effect on me. George Floyd's death was a tipping point, not just for Black Lives Matter movement or the movement to reform policing, but even for many white Republicans like me who once chose to believe, perhaps were taught to believe, that the fight to end institutionalized racism had already been won. Something inside me had been reluctant to believe the system was still being perpetuated today. No more. I've accepted that something in my white heart still needs to change. I'm pushing myself to come to terms with my own heritage, my white privilege, and my flawed beliefs, as well as to develop a better understanding of the experiences that people of color have living in America today. And we see other similar comments, right? So, there's a comment from a journalist from CNN who writes, who actually has a Black wife, who said that he would have been really resistant to the idea, who talks about how the Floyd murder pierced the bubble of his own white blindness. And he says he's, quote, I'm also angry and extremely disappointed with myself for never having seen things for what they were before Floyd's death. I understand why so many white Americans are in denial about the racial bias of law enforcement. Like me, they probably have never had a single disagreeable interaction with cops beyond the occasional traffic violation. White America was and still is largely brought up to venerate law enforcement. Some polling data suggests that things might be different, and I don't know if you'll be able to see this. I couldn't get this larger. But I went back and looked at Pew Center polling data. In November 2009, this is about a year after Obama has been elected, in November 2008, they conducted a poll. And actually, the title of this poll was something like, Blacks feel uplifted after the election of Obama, things are feeling better, right? And this is the result of the poll. You still see stark differences between how Blacks and whites view the police. But in 2009, in terms of the question, do you have a great deal or fair amount of confidence the local police will treat Blacks and whites equally? 38% of Blacks said yes, 69% of whites, right? So, almost twice as many whites said yes to that question. In terms of the reverse, had very little confidence. 34% of Blacks had very little confidence. 9% of whites had very little confidence. So that's almost 4 times as many. Blacks had very little confidence versus whites. Okay, in 2014, we're looking a few years later, but this is about 2 years after Trayvon Martin's been killed. This is the very month, the very month that Michael Brown is killed. Do you have a great deal, it's after Michael Brown's killed, a great deal or fair amount of confidence that local police will treat whites and Blacks equally? 36% of Blacks say yes. 71%, it's actually increased slightly, say whites say yes. But if you look at the very little confidence, it's grown, right, in that period, 46%. But it's also grown for whites too, so 26%, right? So that margin has decreased on the very little. And then we could move to 2020, which is just 1 month before the killing of George Floyd. Pew runs a thing, they changed the question a little bit. Do you have a great deal or a fair amount of confidence in police officers to act in the best interest of the public? 56% of Blacks say yes, 84% of whites say yes. A little bit after the killing of George Floyd, they run one, do you strongly support or someone support Black Lives Matter? 86% of blacks say yes, 60% of whites say yes. It's the highest number we've seen. It's not quite the same question, but it's some indication, right? In addition to the numbers we see, we look at the CNN poll of a slightly different question. In general, do you think that the country's criminal justice system treats whites and blacks equally? 6% of blacks say yes, 29% of whites say yes. In general, do you think the country's criminal justice system favors whites over blacks? 88% of blacks say yes, 63%. Again, the highest number we've seen in 2020. This is after George Floyd, after Breonna Taylor, after Ahmaud Arbery. So we're getting to see a shift in the thinking, and that suggests, in the same way that the protests do, that there's might have been a cultural trauma. And if you look at the 4 factors of cultural trauma, I will go through that in my paper. That those exist basically here. Though the one trick is it really a cultural trauma? Is it forever? Is it a forever moment? Because Renee Graham, who's a journalist for the Boston Globe, reports that actually, if you look at some polls, you start to see some slippage in terms of the support. And you start to see a return to some of the same critiques of Black Lives Matter from whites. And so what I would say is that one of our responsibilities is to make sure that we all continue to stay woke, we all continue to stay vigilant. To the extent that people's minds and hearts have been reawakened, how do we keep them awake? And with that, I'll end. I'm sorry to go over so much.
I want to thank the Houston Law Review, all the editors, Dean Baines, Dean Tennessee, Dean Vetter, Professor Roberts, for this forum and this opportunity to discuss this important and impactful issue, and also to comment on our keynote speaker. Picking up on the themes that Dean Onwuachi-Willig eloquently outlined as the framework to analyze the current social legal climate, and 2020 itself as the summer of the awakening to racism. I pick up on a question she just asked us. Are we in a unique moment of change? Specifically, I query juries. Does the experience of the awakening now prime jurors to view evidence differently, or to convict police officers more readily than in times past? Now awaken from this cultural trauma experience, now woke, is this a moment of wokeness as it relates to asking the question, are American juries ready to criminally convict police violence? Can prosecutors harvest this awakening and convert it into criminal convictions and criminal punishment to end the era of impunity of police violence? Now, I want to put aside the very large and important issue just for a moment of prosecutorial discretion. I want to drop a footnote there and include in that footnote that the response or delay or reaction of the prosecutor in the charging. Why did they charge? How did they charge? Was it a special prosecutor? Was it in response to riots and protests? Were there appropriate resources assigned to make sure that case was litigated thoroughly and successfully? Putting all that to the side, let us briefly reflect on this issue of juries. Once the prosecutors acted, how have criminal juries responded prior to this collective awakening and collective trauma of 2020? The criminal jury's response in several high-profile police-involved killings and vigilante killings of unarmed Black victims like George Floyd have been clear. Dean Onwuachi-Willig laid it out, but I'll just briefly address it as it relates to juries. Trayvon Martin's killer was found not guilty by jury verdict. Michael Brown's killer was found no indictment by grand jury, a no bill. And then you might be thinking, well, George Floyd is different. This awakening moment of 2020 is different because this case was captured on videotape. However, so was the killing of Eric Garner. He was the first to tell us that he can't breathe. But his killer, there was no indictment. The grand jury issued a no bill. And we watched Walter Scott run from the police and get shot in the back. And his jury hung on the issue of murder and issued a mistrial. And to further even highlight Tamir Rice, that our keynote speaker so eloquently described, the grand jury in that case voted that the killing was justified. And there are so many other cases that we could discuss and fully analyze, but due to time, I just stopped there and insert a snapshot that in the last 15 years, only 5 police officers have been convicted of murder for on-duty shootings, although 110 were charged during that period based on the research of Professor Stinson. So we go back to our question, will we see a different reaction from juries following their collective cultural trauma and their awakening to racism? Is there such a thing as an awakened jury? What does it mean for the community consciousness to be awakened or remain primed to address injustices? You know, it might be harder than we think for the majority of jurors to remain awake regarding police violence inflicted on racial minorities. I share this example. A white participant in a documentary called The Color of Fear, a movie often used in racial diversity trainings, maybe even unintendedly explained to us why whites or anyone in the social dominant hierarchical position cannot remain awake to discrimination and even violence against the subordinate racial minority group. That white participant in the documentary said, quote, "It's hard to believe that people could be so cruel against one another," end quote. In other words, to remain awakened, one must keep the reality of this collective trauma of 2020 active and vivid. Without this affirmative effort to maintain the awakened state, it is hard for jurors to believe that police could be so cruel. In all cases, it is hard for jurors to believe that police are the wrongdoers or the wrongful actors. But in the prosecutions of police for violence against unarmed Black men and boys, it is even harder for the awakened state to racism to remain salient, because it is working against a deep-rooted, century-old counter-narrative of their inhumanity. As Dean Onwuachi-Willig stated in her lecture, the polling data is already showing the awakening is waning, and we're still in 2020. Whether or not the larger collective consciousness has awakened to a point to trigger a change in the patterns of juries, a change in their rate of conviction, of police in these cases, we will continue to see what I call the shadow system of justice. Financial civil settlements in these cases. I go back to my list. Trayvon Martin's killer was found not guilty by jury verdict, but his family received a civil settlement by the homeowners association in the neighborhood where the killing occurred. Michael Brown's killer was not indicted, but his family received a $1.5 million settlement. Even though Eric Garner could not breathe and no indictment issued against his killer, a civil settlement of $5.9 million was issued to his family. Walter Scott shot while running away on videotape. His jurors could not agree on the criminality, but his family was given $6.5 million. And Tamir Rice, the case we've also talked about today, the probate court approved a $6 million settlement distributed to his family members. So although these civil judgments or settlements acknowledge that there is some police misconduct, I guess at some level that's a value. It's some valuing of the humanity of these victims. It's hard to accept this as justice. Some might even see it as a financial transaction of sorts, subsidized by taxpayers, an operational cost of maintaining the social hierarchy. As Dean Onwuachi-Willig stated, the privilege of racial status, reinforcing that status and that privilege. Before I move from this section, I also acknowledge the work of Professor Kimberly Crenshaw. Hashtag say her name. And I add to this list Sandra Bland, a $1.9 million settlement to her family, and Breonna Taylor, a reported $12 million settlement in her case. Again, due to time, this list in no way represents all the victims. As stated by Professor Henry Hart, what distinguishes a criminal conviction is the quote, formal and solemn pronouncement of the moral condemnation of the community, end quote. The current state of inconsistent community condemnation of illegal police violence has acted as an accelerant in our American culture instead of the needed deterrent against excessive force by the police. However, the change needed to curb police brutality is more than what law can do. It's a cultural shift towards a universal understanding of human dignity. Maybe we've seen some movement even there as well, as the Minnesota Commission, Department of Human Rights, has filed a civil rights complaint against the police in that jurisdiction, asserting the overreaching human rights issues undergirding all of these cases. So in closing, I share with you a portion of what I wrote to my students in the days after the George Floyd killing. As lawyers and as lawyers in training, our calling is to the study of the law and also to eradicate its unfairness where it exists. I wish I could cite for you the perfect statute and precise case law that would undo these harms and soothe our societal unrest. But it is much more complicated than that. What is clear in all of these situations is that indifference is not an option. Impunity is not acceptable under our laws. In the words of the Ad Hoc Committee Against Racism, quote, people of good conscience should never turn a blind eye when citizens are being deprived of their human dignity. Indifference is not an option. I look forward to the continued discussion and panel and questions that will follow.
Thank you so much. Thank you, Dean Baines, Professor Roberts, Priyanka Kasnavia, and all the students and faculty who made this happen. It's an honor to be here with Dean Lawson on a panel of women of color discussing one of the most pressing issues of our time. And I'm delighted to be part of an event featuring the inimitable Dean Angela Onwuachi-Willig, a luminary and leader in law, a daughter of Houston, a great friend, and a tireless advocate of racial justice. Today, Dean Onwuachi-Willig has eloquently laid out for us a pattern of injustice that's been on repeat play from the days of Jim Crow, where the state and society tolerate racial violence and fail to hold wrongdoers accountable, producing intense cultural trauma. Many Americans understand accountability as incarceration of the wrongdoer, even if within our racially discriminatory and inhumane mass imprisonment system. But here, I argue that state tolerance of individual officers' racialized violence is part of a larger whole. It must be viewed alongside the fact that the penal system itself spends most of its time inflicting pain on Black and brown bodies, and the historical evidence of Reconstruction-era policing and imprisonment's role in maintaining the oppression of formerly enslaved people. This all reveals our criminal system as a mechanism by which the government and powerful private actors control the masses, perpetuate racial hierarchy, and minimize social welfare. Today, Black Lives Matter activists look at the horrific police killings of George Floyd, Breonna Taylor, and too many others, along with the militarized police abusing peaceful protesters and the coronavirus's decimation of people in overcrowded and unsanitary penitentiaries. Many look at these events as confirmation that the criminal system's tendency to wound, control, and thus maintain the subordinate status of people of color is not a malfunction so much as the system's function. Focusing on the system, the call of these activists is for more than prosecuting individual officers. We need to do more to break the unvirtuous cycle the dean identified. This is a moment of radical awareness where people of all races and statuses are decrying the brutality of street policing and lamenting that the United States has the ignoble distinction of being the country that incarcerates more of its people than any other on earth. This moment requires nothing less than a reimagination of how the state can, with justice, serve and protect communities and individuals. You know, when we think about the institution of policing, we lawyers think about its goals, its community protection goals, and then we obsess over how it's failed. It's failed to satisfy community members, failed to reduce crime in blighted areas, failed to treat people with dignity. This obsession with failure and fixing has spawned endless proposals of reforms that will finally work. Broken windows, community policing, hotspots, etc. Instead, we might be better served to concentrate on how policing has succeeded. The institution of American policing has been profoundly consistent and effective at disciplining race and space. In the post-Civil War South, for example, police forces were formed to aggressively enforce vagrancy and loitering laws and compel unemployed Black people into sharecropping arrangements that imposed a de facto form of enslavement. This racing and erasing of space continues. Look at Zimmerman's violence to police his neighborhood, described so poignantly by Dean Onwuachi-Willig. Police serve as the border patrols of middle-class neighborhoods, reflecting and reinforcing the mythology of the suburbs being invaded by minorities. They control shared public and commercial spaces, ensuring that the wrong people stay in their highly demarcated and disciplined areas. Police draw blue lines around Black spaces, just as banks drew their red lines, designating certain places as high-risk, quote, high crime areas. A 2019 study, the latest in a long line of research, concludes, quote, officers' assessments of whether an area is high crime are nearly uncorrelated with actual crime rates. The suspect's race predicts whether an officer calls an area high crime. The racial composition of the area and the identity of the officer are stronger predictors of whether an officer calls an area high crime than the crime rate itself. Having confined people of color to designated places, the police use aggressive stop and frisks, intense surveillance, and military-style home raids to keep them also in their place. In 2012, the Center for Constitutional Rights initiated a class action suit against the New York Police Department over its stop and frisk program. It presented statistics that of the 4.4 million stops between 2004 and 2012, over 80% were of Black and Latinx people, and 10% were of whites. And for reference, New York's population in 2010 was 52% Black and Latino and 33% white. These detentions harmed the dignity of many minorities and were incredibly ineffective at crime detection. Fewer than 3% of the stops resulted in the discovery of illegal objects. A federal district court eventually held that for years, the police had been violating minority New Yorkers' constitutional rights. And during the litigation, one particularly shocking piece of evidence revealed that racialized social control was always at the heart of the program. State Senator Eric Adams testified during a 2010 discussion of the stop and frisk program with the police commissioner, Raymond Kelly. Adams expressed concerns about the program's racial disparities. And Kelly responded that he focused on young Blacks and Hispanics, quote, because he wanted to instill fear in them. Every time they leave their home, they could be stopped by the police. The senator was, quote, amazed that Kelly was comfortable enough to say that. So now let me say something quickly about structure. Police killings of innocent African Americans are for the most part not a matter of, quote, bad apples or cops who choked, as President Trump rationalized them. They are a product of policing structure, from the disproportionate deployment of police in neighborhoods of color to the training that ingrains in police that they must use extreme tactics in maintaining control, given suspects, largely minority suspects, presumed superhuman strength. And the training that every person police encounter is a lethal killer, and so they must shoot first. In reality, the risk of a cop dying from a felon is low. In 2019, 48 officers died that way in total. Compare that to the 990 people they killed. This mismatch in training and narrative make police 21 times more likely to kill a person than to be killed. The risk of on-the-job fatality for cops is lower than that for fishers, loggers, pilots, roofers, garbage collectors, steel workers, drivers, farmers, landscapers, construction workers, and maintenance and repair persons. And in democracies where police are unarmed or lightly armed, police fatalities are extremely rare. Staying on structure for just another minute, consider Breonna Taylor's horrible killing. It was the final act of a process all but designed to produce a tragedy. The police sought a warrant just because Breonna knew a suspect and may have received some of his packages. The judge rubber stamped that warrant without a second thought about the stunning lack of probable cause, and further signed off on it being a no-knock nighttime warrant, the most invasive and dangerous way to do a search. The police organized a heavily armed SWAT team, even though they had determined that this was not a threatening situation. They believed that Breonna Taylor lived alone, maybe with a child, and they could have just knocked in the daytime or waited for her to leave. But the SWAT team, dressed like an army, armed like an army, went to storm that castle in the middle of the night, even suspecting that children might be around. And let me tell you, this is what drug interdiction policing looks like. This is not in any way unusual. So finally, what to do? Well, let me go back to stop and frisk in New York. One could look at those racialized statistics and say, let's do some more police training. One could prosecute the cops who made bad or violent stops. One could try to ensure that the police make an equal amount of stops of Black and white people. One could do all those things. Or one could do what the mayor did when he came in. With the stroke of a pen, he ended the stop and frisk program. Stop and frisks went from a high of approximately 686,000 in 2011 to 11,000 in 2017, a 98% decrease. And far from the city lapsing into anarchy, New York's 2017 crime rate was 17% lower than its rate in 2011. We can make real changes, and we can honor the words of 6-year-old Gianna Floyd when she declared, quote, "Daddy changed the world." And with that, I look forward to the discussion.
Thank you so much to everyone. Please join me in thanking our speakers. I am attempting to share the CLE information. Here it is. So please take a note of this. We will also email participants. We have gone a little bit over. So we were scheduled to end at 1 o'clock, but now we are going to end at 1:15. Our apologies if you need to leave before we formally conclude, but thank you very much for joining us. We are now going to proceed to the Q&A. So as promised, I will share the information about how to proceed, and thank you so much to those of you who've already asked questions. We will in fact take them in the order that they were received. So just a reminder, if you want to ask a question, please use the Q&A function and not the chat. Please address your questions to everyone. And if you wish to ask a question to a particular speaker, just indicate that in the text of the question. But before we take questions from the audience, I would like to give our distinguished panelists the opportunity to respond to each other's presentations. Thank you so much. Would anyone like to respond?
I mean, I'm in agreement. I mean, I think that, I think we're all on the same page. I mean, I really appreciated what, you know, what Dean Lawson said. I think there's very much a reality that, you know, for all the reasons, I think that even the people who wrote the quote said that it's going to be hard for white jurors convict officers, right? That there is a different view of police, that people grow up with a veneration of police. I mean, I have my own memory of when I had my own memory. I was telling somebody the other day of my own memory when I realized I had a different understanding of the police, and it was when I was, remember in elementary school, and I was experiencing a little bit of cognitive dissonance when one of the teachers was, I think there was our PE teacher, who was an African American woman, was telling us that the police were our friends, and there were others. Houston's wonderful because, even because of no zoning and all these things, the schools are wonderfully diverse. And for whatever reason, I think I was one of few African American kids in that room at the time. But I remember thinking, well, that didn't seem to, wondering what other people were thinking and thinking that it didn't jive with my own experience. But no one else was seen to have the same questions, right? But I think that the difference in views and experiences and what people come to know starts at such a young age that it's so hard for people to have that. And when they have no personal experience, there's so little interaction given segregation across racial lines, and people don't even know like the everyday experiences of people of color in relation to the police. I think whites don't know, many whites don't know, that I think it becomes hard for people to think of it. All of our TV shows, like I used to say, I used to love Law and Order, like Law and Order SUV in particular, and I had to stop watching it because, there are all these times when, Olivia Benson or whoever, the detectives are doing something crooked, and it's always, well, they're doing it for the right reason, and so you're cheering, you're supposed to be cheering for them no matter what. So everything that we see in our society has us cheering for officers, even when we know they're flouting and they're breaking the law because their motives are supposedly right. And so there's like just so ingrained that I can imagine it's going to be really hard for all those reasons. And I think that Dean Lawson's right to point out that there is this sense that, okay, that there's this trade-off. We're willing to pay the civil fines and to spread that out across people and make the taxpayers pay, including people of color pay for their own, for the abuse that they endure. And to never ever, if we continue to have a system like we have, a criminal justice system like we have, a punitive system, to never ever have that punishment extend to the police. At the same time, I agree with Professor Gruber that the approach that we have taken to punishment in this country is not necessarily the appropriate. It's not exactly the right approach. So, it's damaging and harmful, and it reinforces so much, and it allows so much. It facilitates racism in so many ways, and allows for people to enables people to facilitate racism by justifying what they want to justify, right? So I agree with both of them, to be honest. Maybe they didn't expect to hear that.
Not always, no. But Dean Onwuachi-Willig, I would also just echo your highlight of jurors and their exposure or lack of exposure, including TV as well as personal experiences. And I think that is what is so powerful about your research and your work that you shared with us today. So in other research, such as the CSI effect type research and implicit bias research, we see that jurors react primarily based on their own personal experiences. So we're going to still see the continual overweighing of that context in the context that is different from the experience of Black and Brown victims of the police violence, and this continual disconnect and where we will come out as far as criminal punishment.
And I'll just add like a quick, in agreement that, because street policing, which is most of the policing, it's, what we see on Law and Order are these, cases where we're doing all the crime scene and we're doing all the detective work and you get the, serial killer murder. That's not policing, right? So policing is street policing. It's armed officers on the street interfacing with human beings. And they are so disproportionately deployed to marginalized neighborhoods that most people don't have any personal experiences with police, especially privileged white people. So what is their experience with police? It's the imaginary of policing from these TV shows, which is why when the Floyd video just went so viral, and as a culmination of these videos, as Dean Lawson said, people woke up. And when people started hearing, well, wait a second, 80% of all arrests are for petty misdemeanors, like things I didn't even know were crimes. They're not, serial killer, repeat rapists. That was a culmination of, a long study and social justice. When they woke up to the reality of policing, I think is exactly when you saw such a change in attitudes towards Black Lives Matter and other issues. And I just hope, as Dean Onwuachi-Willig and Dean Lawson have predicted, although I am a pessimist, I hope the awakening is longer than momentary.
Excellent. So thank you all so much for those remarks. I will now read questions from the participants, and we will see how many we can get through before we conclude at 1:15. So our first question is from Nicholas Genova, and Nicholas writes, when the law governing policing is anemic in the extreme, and when law enforcement may engage in lawlessness with impunity, as is abundantly the case in the US with regard to police racism, culminating in violent abuse and murder, why should the communities targeted by that state violence be expected to abide by the law in response? Would any of our panelists like to take that question? I'll let you.
I guess I'm trying to figure out, I guess it's hard to understand without doing it. So I would say that, it's a fair question. It depends on what your goal is, right? So I think if your goal is to continue, so I think about like the civil rights movement, right? And Dr. Martin Luther King's approach, and the approach about civil disobedience, and part of his approach was, I'm trying to win over people to my movement by I'm breaking the law, but I'm also going to, when I break it, accept what comes with it, right? Like, so that I'm winning, and I'm also going to show people the brutality that's coming with it too, right? So that I'm winning people over to my side, and that will allow us to create change, right? So, I think that it depends. If your goal is to build momentum in a movement that allows for either legal reform or social reform, that's precisely why people should be expected to abide by the law in response. There are moral reasons why, but I think there are lots of civil rights lawyers, and I think the thing is that, it also, I don't know if you're making a distinction between just laws and unjust laws, right? It's hard because you can't engage him in what he means precisely by the question, right? But that was always a distinction that civil rights leaders were making between just laws and unjust laws. And people would say, we're not abiding by unjust laws, but we're accepting the consequences of not abiding by unjust laws with the hope that we will be able to change them. But you could make an argument that I'm not abiding by what are unjust laws because they're unjust. They're like morally unjust laws. But I think because I've made the decision to become a lawyer, so I've made the decision to fight from within, right? And so for me, I've made the decision that I prefer the approach of trying to get reform in that way, right? So that's my decision, and I'm not gonna, so I prefer that approach. That's my approach, is that you would use an approach that respects the law, recognizing that there are unjust laws and that there are just laws, and that there are consequences for civil disobedience, and hopefully what happens with that movement and that strategy is that you're able to gain traction.
Excellent. Thank you so much for your answer. Dean Lawson, Professor Gruber, would you like to respond as well, or should we move to the next question?
Well, I know you have a lot of questions, but I just want to say quickly that I think that something that's interesting is that Black Lives Matter protests do challenge law enforcement's geographic totalitarianism, in that, they go into a space to peacefully protest, and the police come in droves, trying to manage that space and exercise disciplinary authority over it. And the protesters just say, no, we claim a right to also take up space. And this is such a change from the normal disciplining of the area that, the government sends in military operatives and gasses people with banned weapons under the Hague Conventions, and, does disappearances. So I think that is kind of a reaction that's going on now.
Excellent. So we'll move to our next question, which is from an anonymous attendee, and it's a multi-part question, so I will read it slowly, and I invite you all to respond to whichever portion of the question that you would like. So this attendee writes, 1, what roles does historic dehumanization continue to play in the dynamic between white police officers and Black people? 2, what can be done to remove the barrier of qualified immunity? Is legislation or court cases the best course of action to repeal the qualified immunity that makes it so difficult to prosecute police for criminal activity of murdering people? 3, how do we push back against the narrative of victim blaming, the notion that Black victims have done something wrong? And 4, how are we continuing to allow cops to be in the line of work when they are afraid of the people they are supposed to protect and serve? Is it fear or hatred and animosity? Dean Onwuachi-Willig, would you like to respond?
Yeah, sure. So I would say, I think the historic dehumanization plays a huge role in the dynamic between white police officers and Black people. It plays a huge role in racism in general. I mean, Brian Stevenson, who's of course very famous, criminal defense attorney, says, talking about slavery and the lingering effects of slavery, says, it's one thing that's the slavery itself was bad, but what was even more damaging was the sort of the narratives and the tropes that were used by those who supported slavery and slave owners to justify their actions, right? And that those have stayed forever, that those have been more damaging, right? And those remain. Henry Louis Gates, just, his new book, it continues to talk about the impact of those things. And I think they remain with us. I mean, we're talking about the same stereotypes, the same tropes. They have adapted over time, but they have remained. And they are part of the racism that continues to justify so much subordination on an individual level, but also on a structural level. And that's used to explain the subordination of Black people or the position of Black people, right? And so absolutely plays a role. I think another thing that plays a role in the dehumanization of Black people by police is the increasing militarization of the police. And, because when, I think that you militarize the police and you think about being in war, I mean, I think I've not ever been a soldier, but I think part of what I understand from people who have is that you don't necessarily think when you're in war of the people that you're fighting against as human beings, right? You almost can't, right, in order to engage in those acts, right? And so if you are engaged, if there's increased militarization of the police, and you are policing particular communities, and the particular communities are being over-policed and watched all the time, then I think absolutely there's been this dehumanization of particular communities over and over again. I think I'll leave the qualified immunity questions probably to the criminal law people who are actually officially criminal law scholars. They can answer them much better than I could, and so then since they're here, I won't do it. I guess I'll stop there. So, and I can go back to other questions if some of the other ones are victim blaming and other things.
Dean Lawson?
I would just echo some of the ideas about the lingering meaning of minor criminality as it relates to the victims that we outlined today, and how it's so consistent that they are encountered for these same minor things that were part of the Jim Crow movement, and in other systematic, mainly social dominance type of pressures in our American fabric. And those are the same ones that become the trigger points that become lethal for Black people, where they're just ordinary daily safe encounters for other people. So I think that history is still strong, it's still vibrant, and we still hyper scrutinize every minor infraction of Black people in a way we don't of other members of our community. And qualified immunity, I think, is complicated, but I don't think it's a limit on criminal prosecution. It is a limit more on the civil side of the case, but I think there's this thinking of the protection, and I think I would say that the union agreements, collective bargaining agreements, are a larger barrier on the prosecution than some of these, than qualified immunity even itself. The qualified immunity, I believe, is a major barrier to plaintiffs, to victims who become plaintiffs on the civil side, because it creates a huge access to justice cost, because the case is over litigated on this issue of qualified immunity. It has interlocutory appeals automatically that delay the progress. You know, average case like that would be 5 years, and citizens can't financially sustain those kind of cases. And even attorneys, we have some, champions in the civil rights area, but most attorneys cannot afford to take on these cases because they're not successful cases. Because again, every minimal prior conviction, infraction, etc., of the now victim, even as was pointed out, even if the police didn't know it at the time of the encounter, is used in the civil case to diminish the victim or the victimization and the value, if any, of the civil remedy of the case. And I would give some time for Professor Gruber to add.
Excellent. Professor Gruber?
Sure, I can add something quickly. Actually, one quick thing, one a little bit longer. Colorado recently ended qualified immunity under state law and state constitutional law, which, states can do. Again, with the stroke of a pen. You don't need to litigate, Now, do I have hope that that is going to change things, in a meaningful way, given all the litigation barriers that Dean Lawson just mentioned? I don't know. I think these large structural changes, like the stop and frisk story, really can get things done quicker and better. And then I just, something that Dean Onwuachi-Willig said made me think about a study that I had just come across. So it just blew my mind. So there's this 2018 study. It's in the Proceedings of the National Academy of Sciences. And this researcher got a rare demographic glimpse at militarized police because Maryland happened to keep these geocoded records of their SWAT teams, right? And the study found that in Maryland, quote, militarized police units are more often deployed in communities with large shares of African-American residents, even after controlling for local crime rates. So that should just be no surprise. And further, the author found that using nationwide data on police militarization, militarized policing failed to enhance officer safety or reduce local crime rates. So again, We're looking at what fails, but what has worked in militarized policing? More of the same: spatial and racial social control.
Excellent, thank you all. So here's a question from Deveda Francoise. Do you feel that Blacks in America that are not African American experience the same level of cultural trauma that African Americans do when they witness or hear of tragedies associated with what some refer to as the new status quo?
Yes, I do. So I think it's a little complicated, but yes, I do. I mean, I think number one, I think that one of the things that so we know a little bit about research in other areas, right? So one of the things that we know is that even if people come in with different attitudes, right? Because you know, the stereotypes about Black African Americans, right, is global, right? And so, right, so even people who are Black in other parts of the world might have internalized them, right? And so may come here with some of those same stereotypes. And even if they don't necessarily associate themselves or associate themselves mentally with other African Americans initially, and therefore may not experience that trauma initially, what we know is that ultimately, right, that people acculturate to their host group, right? And so that happens for Black immigrants. And so people become Americanized by racism, right? So, and if you talk to Black immigrants, they become Americanized by racism. And the other thing we know is that even if we see some educational benefits, right? And so second generation, first generation, Black people from other countries tend to do better in the higher educational sphere, job sphere than the African Americans with long-term roots in the country who descend from slaves on both sides of their family tend to do better in that sphere, and that's a major problem. Absolutely agree. That's a major problem. Those advantages disappear by the third generation just because of the ways in which racism works, right? And the distinctions are no longer made, and the acculturation process. And so yes, I think so. There might be a period until people become Americanized by racism where first generation Black people don't, but absolutely. I mean, and I think there are lots of Black immigrants who are also find themselves in this, like Amadou Diallo. I mean, you also find Black immigrants who are among these victims. And so I think even because of that, you would see that kind of mental association.
I would just add that the international lens that we saw and the global response to the George Floyd video and the killing itself is a reaction to international law and genocidal doctrines, where the impact is to destroy the group in whole or in part. And however you maybe self-identify, that fine line in your Blackness may not be obvious to the actors that we're describing that may identify you and treat you in these ways. And the group trauma, therefore, is internalized, that you can be equally as picked out of the crowd in a way that you can never get out of the group. And that's what makes genocidal type harms so horrendous, because you're being selected based on immutable characteristics that you can never erase.
Professor Gruber, do you care to comment?
I think that was perfect.
Excellent. So actually the next thing that we have is a comment from Athena Muta. And I think that this is a moving example perhaps of collective trauma. So I will read it for the benefit of the audience. She writes, "Where were you when Zimmerman was acquitted? The Black sorority Delta Sigma Theta was holding centennial celebration in DC, 40,000 Black women in DC, thousands in a concert, and the acquittal announced in the middle of a concert, the howling of pain, crying, tears, Indiari begins to sing to try to console." So I don't know if you all want to share where you were or comment on her comment.
Yeah, I was luckily in my home when I was able to privately engage in my own pain. So, but I do remember, it's one of the things I think that is proof of the trauma. I remember where I was. I remember where I was when I when I first thought there'll never be a conviction in these cases. I remember what case it was in response to. I remember when I remember what was the last video I could make myself watch to see, look at. I mean, I think that, and I think if you ask many African Americans, they could tell you the answers to those questions.
Dean Lawson?
It's interesting because of my proximity in Florida and my role as a law professor and lawyer here. I can't remember the verdict because it was so anticipated. And we were working and asked to work and talk to communities of color in advance of the verdict to prepare the community and explain to them what they were really watching, because a lot of the Black community expected, justice. And Trayvon Martin's home is right, down the street from where the law school sits, where I am right now. And so this community was expecting something, and we had to deliver or prepare them for the message that seemed imminent from how the case was proceeding. And I think I was already there before it occurred.
Professor Gruber?
Yeah, I'm not sure I even watched the verdict in real time, but heard about it on the news. I watched so much of that trial by TV, obviously out of interest, but for pedagogical reasons. But like Dean Lawson, I wasn't particularly surprised. I was angry at so many things, but and unlike Dean Onwuachi-Willig and Dean Lawson, I don't understand the pain that they were feeling and that Dean Onwuachi-Willig was feeling about the risks of this to her son, right? Like, that's just not something that I personally experienced. I will say this just quickly, and this is, I don't want to open up a can of worms, but a lot of, I have studied the intersection of violence against women and incarceration and prosecution. And a lot of victims see this criminal process, this process of prosecuting and incarcerating, as something that's going to be liberating and psychologically healing. And some do feel that. But, what you hear time and time again in some of the psychological literature on victimization is that closure, that process is often an empty process. And especially if it doesn't serve to prevent or fix the problem, that, you could have victims almost over-investing in this idea that ultimately the criminal process is going to be the thing that solves the pain. So I throw that out there. That might open the can of worms, but just.
Well, I'll just throw something else related to that. This question made me search my mind. Where was I really? Okay. I now remember where I was. I was at dinner with some friends. They were not Black. They were white and Jewish and had a young teenage son. And he, throughout the meal, kept going back to and repeating, but he was a kid. You can kill a kid and not get in trouble. He just was like, as a kid, he felt vulnerable, that there was no criminal punishment for killing a kid. And so I think that goes to Dean Onwuachi-Willig's work and its broadness of the collective trauma across race and different groups experiencing it in a unique way, but still experiencing it. And like you were saying, Professor, this child was expecting some vindication in the criminal justice system. Like, there's no way an adult can kill a kid and not go to jail.
Thank you.
Yeah, I think that, we happen to be in a system, well, I know what society, we live in the U.S. society where punishment is one of the ways in which we communicate what we value. And so for me, I can imagine for the direct victims, right? You know, I'm talking about a broader victim community, a entire community that's victims, but for the direct victim, I can see how that would not solve it because it never brings back the person, right? And you knew the person directly. All the moments where when you think about when you lose someone, you can't say hello to them, you can't call them up, all, you know, all the things that all the ways in which you'll never interact with them again. But I think the what it would communicate in terms of someone being not just charged but convicted in a society that communicates what it values through that, I think would be meaningful for Black people as a whole.
Thank you so much. So we are basically at time. So unfortunately, we've not gotten to all of our questions, but I just want to thank our participants so much. My apologies if we didn't have time to respond, but thank you so much for joining us. And thank you again to our amazing speakers for this thought-provoking conversation. And a final request, could our speakers please remain online for a photograph? Thank you all so much. And we appreciate your being with us.
Thank you all.
Thank you.
Thank you so much. Thank you for coming. Thank you.